Nobody really wanted to be put to death. And, you know, they claim their innocence and everything, but the ultimate subject was, I don't want to die.
This man is one of the dozens who spent time on death row since capital punishment made its comeback 14 years ago. But his death sentence didn't stick, and neither have most of the others. In fact, New Jersey hasn't seen an execution since 1963. The death penalty on the docket, this time for due process.
Major funding for due process is made possible by the New Jersey State Bar Foundation, committed to educating the public about the law. Additional funding is provided by Lawyer's Diary and Manual, publishers of print and electronic information for and about the legal community, including the legislative manual.
It's in the headlines nearly every day. Yet another execution in yet another state. At least outside of New Jersey, capital punishment seems to be making a comeback. I'm Ray Brown, and while we're still a far cry from the nation's all-time record of 199 people executed in just 1 year in 1935, the 1995 figure of 45 executions holds the record for any year since the death penalty's reinstatement 20 years ago. And if the numbers so far in '96 hold up, this year should break that record again. Of course, New Jersey so far has bucked the national trend, and that's where Sandra King picks up the story. Sandy?
Ray, this state is an interesting study when it comes to capital punishment. On one hand, there are polls that show that 75% of the people are for it, and New Jersey is one of 38 states with laws that do provide for punishment by death. But there's been no execution here for more than 30 years, and though in some quarters that is cause for distress, we found one Warren County man for whom that restrained approach to public policy was literally a matter of life and death.
When I was sentenced to death, I went to Trenton, and I was scared to go to prison itself because I've never been there before. And then when I got on death row, everybody was saying to me, you know, you're going to be executed right along with the rest of us. It was scary.
In 1987, Raymond Keiss became one of the more than 40 convicted killers sentenced in New Jersey to die by lethal injection. But 8 weeks later, he became one of the more than 30 to have their sentences overturned or thrown out, changed to life in prison. And last year, still insisting he was innocent, he was finally retried, found guilty only of conspiracy, released for time served. But he's haunted still by his time on the state's most chilling cell block.
You would stay in the cell about 23 hours out of the day. You'd get like a half-hour recreation. You would take a shower. But when you left the unit and you went to like the clinic in the prison and everything, all movement stopped throughout the prison, and you were in handcuffs and shackles.
And conversation on death row, he says, was as grim as the future they all faced.
How long they've been on death row, how long they've been in the prison system, if we're ever going to be sent, you know, executed.
And most, of course, would not, or at least not for a decade or more. Robert Marshall, convicted of hiring a hitman to kill his wife, was on death row back then. He is still there along with 9 more, although others, like serial killer Richard Biegenwald, have come and gone, thanks mainly to the state Supreme Court.
Absolutely.
But Marshall, who's exhausted nearly all appeals, not only state but federal too, could become the first to die in this chamber.
There are 2 people, Marshall and Martini, who are up with, they have post-conviction relief motions before the state Supreme Court. If the court permits the post-conviction relief motions, then I think they may have a couple of years more to go of appeals. If they don't, they may very well be executed before this year is out.
Martini says he wants to die, but if he gets his way or Marshall loses his, they'd be the first to be executed here since the penalty was reinstated in 1982. The first, in fact, since 1963. And if you believe the polls, most people think it is long overdue.
In New Jersey, we've had a Supreme Court that, for the most part, has been led by people who have an opposition to the death penalty because they believe that it is either cruel and unusual punishment or that it is unfairly applied.
But a recent rash of executions across the country has given comfort to penalty proponents like Bernard Kenny.
The crime rises to such a height that only a full, so to speak, eye for an eye will make it even.
Still, so far, the opponents have had their way.
It has no effect other than to brutalize society, and I don't understand the death penalty.
And Paul Castellero claims his client, Raymond Keiss, is proof that capital punishment is just too great a risk.
The potential for injustice to be committed is so great. I just know during the times that I've been a lawyer in the last 20 years, there's been countless cases I've actually handled where the person's innocent and in jail doing life. In Mr. Keiss's case, under a death sentence at one point in time.
But the families of the victims, like the husband of Gail Schaller, kidnapped, raped, and murdered by a man who wasn't sentenced to death, and the father of Deidre O'Brien, whose serial killer too escaped the ultimate sentence, say they're the ones who have not gotten justice.
The jury is slowly buying over the years excuses why the convict has committed the murder.
So they want New Jersey's statute made tougher, and they applaud a law passed just last year that would allow the families of victims, like the parents of Megan Kanka, to tell a jury why they believe the murderer should die.
The potential that has to inflame the jury and for the jury to return a death sentence only increases the likelihood you're going to have an injustice committed in particular cases.
And an Essex County judge late last year called the law unconstitutional. So until the state Supreme Court has its say, some capital trials, including the Kanka case, will stay on hold.
The victims' families, they're the people who should be the ones expressing that loss on behalf of society as well as themselves. So I think absolutely they should be able to go before the jury, because that's what it's all about.
All it is to inflame and emotionally anger the jury even further and enhance the possibility of a death sentence. That's wrong.
Of course, there are plenty who say that is the whole idea, to get more death sentences and to make them stick. For just an idea of how deep the feeling runs, consider this. In Utah last month, there were more volunteers than the state could use to carry out an execution by firing squad. And here in New Jersey, since 1984, there's been a surplus of volunteers to push those plungers for the lethal injections if or when executions do in fact resume here.
Sandy, it certainly looks like public sentiment overwhelmingly favors the death penalty. But when we look at surveys, sometimes it depends on how the question is asked. For example, if people are told the alternative is life without parole, it changes the results somewhat.
Well, we wonder also whether they're ever asked the question in terms of dollars. Here in New Jersey, for instance, it costs less than $1 million to keep someone in jail for a life sentence, 30 years or so. It costs $7 million or more, they tell us, to take somebody from conviction through appeals, on death row, and finally to execution. Given the hysteria about saving money and cuts in taxes, wonder how they'd answer then.
It's another way to look at it. And when we come back, we'll hear from both sides as an anti-death defense lawyer takes on a pro-death prosecutor. Stay with us.
I believe in capital punishment. You commit the crime, you should be able to do the time.
If there are people on death row, I say use it. It's there to use it. I'm for the death penalty anyway, so.
That's a tough question, you know. I'm not for the death penalty anyway because I don't believe in taking life regardless. So, that's a tough call, man. It's a tough question to answer.
Murdered someone, and if found guilty, should be punished. I mean, and that at that point in time, I would say yes to a death penalty, not for minor crimes. I mean, so I think that's a fair system. If you kill someone, you get killed.
In Florida, a triple killer is marking his 22nd year on death row. 1/4 of Georgia's 100-plus death row inmates have been there since 1980 or before. It's not just New Jersey with its 10 on death row and no executions that seems caught up in the logjam. For some answers on how we got here and what's likely to come next, we turn first to First Assistant Passaic County Prosecutor Boris Moshula, who as a Deputy Attorney General argued 4 death penalty cases before the New Jersey Supreme Court, and Lawrence Lusberg, who as the Director of the John J. Gibbons Fellowship in Public Interest and Constitutional Law at the law firm of Crummy, Del Deo, Dolan, Griffinger, and Vecchione, has participated as amicus and defense counsel in numerous federal and state capital cases. Welcome, gentlemen.
Thanks, Frankie.
Boris, let me ask you this question. You saw Paul Castellero in the opening package say, as an intelligent guy, a lawyer, and I think sincerely, he just didn't get it. He doesn't understand the need for the death penalty. In succinct language, can you tell us what the need is?
It's an appropriate penalty for a type of murder, very limited class of murders, given society's feeling that those class of murders devalue human life. And the way we bring it back is by having the execution of the defendant. The devaluing of the life of the victim is what we're talking about here, and it's society's balance.
Fair to say that we're talking exclusively about punishment, not deterrence and those other kinds of things?
Yeah, obviously rehabilitation is out the window. Deterrence, it's always been a toss-up, and I'm at this point ready to say even if it doesn't deter, we have other penological objectives, and clearly retribution, punishment is the key issue here.
Larry, what is your response?
Well, my response is that the death penalty is just meted out too arbitrarily, too infrequently, with too many impermissible variables to ever have any appropriate effect, whether that be deterrence or even punishment. If you look, as I have, at the full universe of cases in which the death penalty could have been sought but wasn't, or whether it was sought, or even whether it was imposed by a jury in New Jersey, you can't meaningfully distinguish between one case and the other. You have horrible cases, cases where a defendant drove nails into small children's head and a jury didn't impose the death penalty. We saw the Scholar case in the film clip, and the death penalty wasn't imposed there. You can't look at that case and square that result with the result that was reached in, for example, the Marshall case, which was discussed. It doesn't make sense, and as a result, getting the death penalty imposed on you in New Jersey, at least where I've studied it, is like being struck by lightning. And the Supreme Court, when they struck down the death penalty in 1972, said, that's wrong, that's immoral, it's not proper.
When you say it's arbitrary, then you're not saying there's no due process in a particular trial, but rather there's no way of saying who will get it and who will not get it based on the facts of the case?
Well, there have been problems, of course, in the due process area. And, you know, people express frustration about how long it's taken in New Jersey to reach the point where there may be an execution this year or next. But that's normal. It takes a while, once the death penalty is reinstituted or instituted in a state, for the courts to work out how you're going to go about this, what processes are required, what jury instructions are required, how to make it as fair as possible. I have my doubts as to whether it ever can be fair, but it takes a while to get to that point, and that's what a lot of the delay has been here in New Jersey. That's why there have been so many reversals.
We'll come back to the delay, but Boris, I'd like to hear your response to Larry's claim that it's arbitrary in the sense that you never know whether some guy who's done a heinous thing is going to not get the death penalty and somebody with a less heinous crime may.
I don't see it that way. All the defendants that we're talking about probably deserve the death penalty, but we're talking about a system, at least in New Jersey, that is heavily skewed against the imposition of the death penalty. We have something which is not traditional in criminal trials, and that is the jury is told, if you do not agree, can agree on a sentence, the defendant will be sentenced to life. I consider that a very big door for a jury to escape and not face that ultimate penalty. You have an opportunity for the defendant to address the jury and basically plead for his life. Factors like that and the system of proofs that are built in to the capital punishment process really skew the system to get those few people that truly deserve it. And I feel that under our system, that is exactly what's happened. The fact that there are some out there that deserve it but didn't get it doesn't mean the system is being imposed arbitrarily. If anything, the winnowing down, the few people that are out there that are on death row that have been sentenced to death show that the system works.
Larry, in this winnowing down process, do race, class, status make a difference in your view?
Well, I think it's become absolutely clear that they do. I argued before the New Jersey Supreme Court a few years ago in the Marco Bay case, and Mr. Bay is one of the people that's on death row, that at that time the death penalty in New Jersey was being disproportionately imposed by juries based upon race. Just in the last few weeks, new data has emerged, and this is not data that has been put together by public defenders' offices, by defense attorneys such as me, but this is data that was compiled by the court that shows really beyond any statistical doubt that the race of the defendant plays a role in whether a jury sentences that defendant to death or not. It also shows that, in fact, the numbers are truly overwhelming, that the odds of a black defendant getting the death penalty, once you control for every other variable, how serious the case was, the person's record, I'm talking about a rigorous statistical analysis, that a black defendant has odds 10 times greater than a white defendant of getting the death penalty imposed upon them.
Is that troublesome? Yeah, let's talk about those statistics. This is not a new argument. Back in 1992, when the Supreme Court was first considering this proportionality review, the race claims were made.
And the first two in New Jersey would probably not be black if the current lineup, to use a terrible word.
That's correct. Yeah.
But you say that those numbers are not accurate? Or?
The numbers arguments were made, and not only in terms of how it's being applied by juries, but also by prosecutors. One thing about this recent information is that prosecutors, in terms of being a target of the arbitrariness in the race claims, it's just non-existent anymore.
Well, putting aside the question of who's doing it, would it trouble you if the bottom line were, as Larry says, the statistics show, that people of a particular race or class are the ones who are primarily the object of the death penalty?
I have a natural distrust of statistics. They're showing numerical trends. No one has proven, or frankly even asserted in New Jersey, that any of the capital cases that have gone along, that the sentence in a particular case was a result of some type of racial discrimination or some other type of impermissible factor. So we're dealing with numbers. We're dealing with numbers that have to be studied more, and I'm not saying there is no value to statistics. I think there's an overemphasis in this field in terms of using the numbers to show what is real when, and the reality of the situation is they are only numbers.
Larry, will the court ever get to address this concern?
Yes, the matter is now before the court in the proportionality review that...
proportionality being when the court looks at the question.
What happens is, in New Jersey, after there's been a trial and the death penalty has been imposed, there's an automatic appeal to the New Jersey Supreme Court. If the death penalty is then affirmed, as it has been in a number of cases recently, the court undertakes what's called a proportionality review. That's meant to distinguish and make sure that the particular case is not aberrant in some fashion. For example, if you had 99 consecutive convenience store robberies with murders that ended up not having a death penalty imposed, and in the 100th identical facts, a death penalty was returned, the court might say that's disproportionate, and that's an example that the court itself has used. But proportionality review is also used in another way, which is to make sure that impermissible characteristics are not intruding upon the death penalty process, and that's going to come up now in this Harris case. You know, I think Boris would be a lot less suspicious of statistics if they came out his way. It turns out...
Is that true, Boris?
Well, perhaps. Overall, it doesn't seem to work. Let's deal with some real numbers here. Since the inception of the death penalty, our current law, we've had about 350 death penalty cases statewide. Of those, only about 150 have even reached the penalty phase. There's been a process by which other verdicts or whatever happen. Then we take into the account the standard of appellate review. We have a court that's looking at this death penalty case back and forth, every piece, no stone unturned.
Let me be rude for a minute and interrupt you. One of the arguments we heard in the package was the statement that because the court is anti-death penalty, it's using procedural mechanisms as an excuse to subvert the death penalty. Is that your argument?
Not really.
If not, is it an argument that you've heard?
I've heard the argument often, and I can understand the frustration, but I could also understand...
I think it was Senator Kenney who said it.
Okay. There's a certain amount of time that I agree that has to take place in terms of finding out what a constitutionally valid system is all about, testing out the law. A lot of the reversals occurred as a result of one ruling, but it had its impact on other people. I think we're beyond that point. I think the court is comfortable with the system of capital punishment in New Jersey, but in 1996, as we speak today, the bottom line is that only 4 cases have survived the court's review, both the initial appeal and proportionality review. So we can talk about trends, we can talk about sentencing, but the bottom line is we have this handful of defendants who are there, who are still subject to a valid execution The rest have actually been, taken out of the system.
Larry, one of the issues that death penalty advocates have talked about in great detail and many favor is the concept of the victim's family having the right to speak at sentencing, another issue that's in the courts. What's your feeling about that, and where do you think we're going with it?
Well, we'll know pretty soon where we're going with it. The matter scheduled for argument in the New Jersey Supreme Court on February 27th. I think it's the day that this is being aired. So we'll have our answer to that real soon. In the court, I suspect, will rule on it sometime. I mean, obviously, I'm vehemently opposed to that. I understand why victims want to be heard, but the potential for all kinds of further arbitrariness and improprieties really abound. You heard Paul Castellaro talk about how it'll inflame the passions of the jury, and that's clearly the case. But there's another invidious aspect of it, which is different types of people are murdered and are killed in New Jersey. And imagine the unfairness of having somebody who has a lot of friends and has a lot of people coming forward, able to therefore produce a huge show as to what the impact on the victim's family and friends are.
Larry seems to be saying that the status of the victim may have an unfair impact on the death penalty decision if we allow victims' families to participate. Boris, what do you think?
We're not looking at victim comparisons. Each particular case focuses on the victim there. I mean, that's why we have victims' rights organizations.
But does it make a sense in a social sense, because I know you have philosophical and other concerns about this, that if the victim is someone that no one knows, a homeless man, that it's less likely that there'll be personal advocates of family members for him than a person who has a family and who has done well in life? And does that kind of disparity trouble you as an argument against having victims speak at sentencing?
It doesn't trouble me because I think that the prosecutors are in every case, and the prosecutor can be making the argument on behalf of the victim in terms of the evidence.
Then why have victims' families speak if the prosecutor is going to be there all the time?
Prosecutor is an integral part of the process. The law as it's written now, even though it's been declared unconstitutional, does not give victims' families an absolute right to come forward. It's a joint process, but clearly in terms of the well of information, the well of emotion and feeling, that's coming from the victim. I also have a big problem, a big disagreement with the fact that we're going to have these shows in court. I don't think that we can simply assume that every single presentation of victim impact evidence is going to be this hysterical type of show.
It's hard to conceive of it being calm given the stakes and the harm that's been done to the family.
There have been numerous instances where courts in other states that have ruled on this have said this is a very brief statement, it was a non-emotional statement, it was just to give the jury a focus that there's somebody there on the other side of the process.
Larry, do you think it can be controlled, or is it inherently abusive?
The entire purpose of this testimony is emotional. The entire reason to have it is to show the jury how deeply hurt a family is as a result, or friends may be, in fact, as a result of the death of the person. It's very hard once you're in that realm to limit it by some evidentiary or neutral principles. No, I can't imagine that this could ever be done in a way that really can be limited in the way Boris seems so optimistic that it will be.
I think that between the Supreme Court, who will decide the case, and if allow it, I am sure that will give us some idea as to how it's to be presented, and the prosecutors, and in fact victims too, we have to keep in mind that if they are hysterical presentations, if they are the type that intrude on the due process rights of a defendant, we're looking at a reversal. We're looking at basically what the victims, the prosecution does not want.
It's
so
hard
it's
hard to believe Mrs. Kenka wouldn't be a powerful advocate that could significantly, by her recounting of legitimate human emotions, really be decisive in that sense.
We recognize that this is an area with the potential for emotion, clearly. That is why the law, as written, really narrows that presentation of victim impact evidence to a very small factor in the overall weighing process. It's not let the victim put on evidence, let the defendant put on evidence, so let's decide. It is a very small amount of the law, and that was deliberately done because of recognition. Another thing, very ironically, there's a situation where now, as I mentioned before, a defendant can get up and address the jury, and the claim was made in opposing that this would be a very emotional thing. Here's a person standing there begging essentially for his life. And the Supreme Court said, we don't think so. We don't think that that's going to be the common situation. It's hard for us to imagine that this brief statement will in any way influence the jury unduly. Well, the same argument goes to the other side. I think it works both ways.
The Kenka case is on hold, as are others in which victims want to speak. That issue is going to be decided by the court. Let me ask you a question that touches both of your feelings and that it may not be so readily resolved in a deeper sense. John Martini, a man currently, one of the 10 currently on death row, has said he wants to be executed. And there's a question about that process. Larry, how do you feel?
Well, I understand the difficulty of the legal issues that are involved. What I when I think about this, I think that society has an interest in assuring that when this ultimate sanction is going to be imposed, when society is actually going to take somebody's life, that we have to be awfully sure that it's the right decision. And that's why we have the heightened safeguards that Boris has discussed. That's why we have this mandatory appeal to the New Jersey Supreme Court. And that's why I think we should also require, not as a matter of the defendant's preference, but as a matter of our society's own feeling that we're not going to execute somebody if there have really been errors, if there have really been problems.
So it's not his shot to call
it
unless
really
due process is satisfied. Boris?
It's not his shot to call until a certain point, and I think in Martini we've reached that point. We've had 2 rounds of appeals. Our Supreme Court looked at all of it and said basically the valid death sentence is there. We've had an independent finding that the defendant is competent to make this decision, very forcefully argued by his own lawyer. I think we're at a stage now where we have to start thinking about whether the opposition to his willingness to be executed is more the furthering of a cause or the furthering of a defendant's wishes. I think it's
Quick
the
answer.
former.
Given the overwhelming cost associated with the death penalty, will there come a point at which the public will say that's too much to pay, life without parole makes more sense fiscally? Larry, then Boris.
Absolutely. It's going to happen. People, as you noted before, polls show that where you give somebody the cheaper option of life without parole, people are in favor of it.
I don't buy it. Those numbers have never made any sense to me. I don't buy the statistics. I don't think the cost factor is that great.
Both of you have made a lot of sense to me, and I appreciate your being here. And that's it for this edition of Due Process. But we'll be back next week to focus on a question we've only touched on today. What role does race play when it comes to criminal justice? Are the rules different for black and white? Are we as a system as fair as we should be? Race and the law on the next Due Process. Till then, I'm Ray Brown.
When I was sentenced to death, I went to Trenton and I was scared to go to prison itself because I've never been there before. And then when I got on death row, everybody was saying to me, you know, you're going to be executed right along with the rest of us. It was scary. You would stay in the cell about 23 hours out of the day. You'd get like a half-hour recreation. You would take a shower. But when you left the unit and you went to like the clinic in the prison and everything, all movement stopped throughout the prison and you were in handcuffs and shackles.
Major funding for Due Process was made possible by the New Jersey State Bar Foundation, committed to educating the public about the law. Additional funding was provided by Lawyer's Diary and Manual, publishers of print and electronic information for and about the legal community, including the legislative manual.